Welcome to today's webinar, Determining Co-Founder Equity and Compensation. I'm Gabby Ababa, Growth Marketing at Atrium, and your moderator for today. Before I get into the webinar logistics and introduce our speaker, I wanted to let you know a little bit about Atrium. Atrium is a corporate law firm and technology company providing fast, transparent, and price-predictable legal and business services to startups through our technology platform and innovative subscription-based pricing. Atrium is reinventing how professional services are delivered with a focus on improving the client experience. Founded by Justin Kahn and backed by Andreessen Horowitz, YC, General Catalyst, and more, we are trusted by over 400 of the top startups and hyper-growth companies in and outside of Silicon Valley. Now on to logistics. This webinar will roughly be about 45 minutes of content and Q&A. You can submit questions at any point during the webinar on the left side of your screen. And now I'll pass it over to our speaker, Natasha Allen.
Good morning, everyone. My name is Natasha Allen. I'm one of the managing counsels at Atrium and a member of the General Corporate Core Group. I've been practicing for a little over 11 years, both in corporate tax and doing some M&A as well. So I'm well versed in terms of just dealing with founders and putting together a founder group right from the get-go. I also did work in a startup at the beginning stages of the company, so have a little bit of background in terms of how things can go. So today we are going to talk about 4 or 5 different things relating to how to consider allocating stock among co-founders. To be honest, today I was going to start off saying that there's no exact formula in terms of figuring out how to allocate stock amongst founders. And then I went online and found that there actually is a founder allocation distribution calculator. Regardless, I think that this presentation is still worthwhile because even though there is a calculator, the calculator still requires inputs that we're going to discuss today in terms of assessing the different contributions that a founder has made to a particular company. So in terms of what we'll be talking about, the first slide will be dealing with defining what's critical to decide up front. Then we'll talk about tips for managing your cap table. Third will be founder stock split and compensation. And finally, we'll talk about equity-based comp and early exercise options. So what to consider when allocating shares. So the first thing to start off with is generally, do you have a co-founder right from the get-go, or if you're looking for a co-founder? So we had a circumstance where there was an individual who knew himself that he wanted to start a company and was still looking for a co-founder, and I've had this situation with many clients. And the debate was whether, do we wait for the right ideal co-founder, or do we move forward and incorporate the company? So we're going to focus mainly on, for this presentation, with respect to a certain scenario where there's 1 or 2 plus, co-founders that are looking to start a company together. In the latter example, if you're just one individual looking for a co-founder, rather than stalling to incorporate your company, you could always incorporate, distribute the shares to yourself, and then later on there's a mechanism where you can then contribute shares back to the company in order to compensate a co-founder you find in the future. Finding a co-founder is kind of, think of it as developing a very strong relationship. So you want to make sure that you do pick the right individual and that you both or all 3 or whatever the group number of individuals have the right chemistry in order to move the company forward. So other things to think about when considering how to allocate stock. So just as an aside, equity is kind of, the main purpose of allocating equity to founders is to incentivize them for future contributions and to ensure that there's some commitment to long-term growth within the company. Most common factors to consider, like I had mentioned before, one of them is, what will the co-founding team members be contributing to the future growth of the business? And that means, will they be technical? Will they be marketing? How are they going to help progress the company moving forward? Another consideration is allocating shares of the company to match the reward that is expected for future work. So if there is, fairly equal understanding in terms of how the co-founders are going to be in terms of contributing for the future growth of the company, then the distribution of the shares should be relatively equal. You can always adjust these numbers if perhaps in the past somebody had added some seed money or they contributed the code or the idea. But typically, if you think that the contribution going forward between the founders will be relatively equal, you should probably distribute the shares relatively equal. Now, in terms of the distribution of shares being equal, you never want it to be strictly 50-50 because you never want to, especially if there's only two co-founders, because you never want there to be a deadlock. So it's always better to have maybe 49-51% if that's in the scenario when there's only two co-founders. A final thing that should be considered that's somewhat critical is to make sure that you impose time-based vesting. So I know some of you may be aware of, when you have employees, you have stock option plans, and typically you have a vesting schedule. The same vesting schedule should be implemented for co-founders. And what that does is it allows that co-founders who on day one, who are committed to making sure that the company moves forward, will also be there a year from now, moving forward and pushing the company forward. It prevents founders from, on day one, saying that they're all in and that they received the stock, and then on day two, leaving the company with a huge chunk of the company's ownership. So it's a good way to not only protect the remaining founders, but also just to protect the company itself. Typically, you find vesting could be anywhere from 4 to 5 years with some type of cliff period. So what that means is that after some period, usually it's 1 year, a chunk of the shares will then become vested and become owned, or ability for that individual to acquire those shares if they're options. So just to wrap up in terms of defining what's critical, think about when you're going to be adding your co-founder, whether it's before or after, and taking into consideration whether you should just move forward with incorporation if you're looking for someone, or if you have your co-founders at the beginning. What will the co-founders contribute to the future growth of the company? Again, if you think that contribution is going to be equally distributed, then perhaps the shares should be equally distributed, with that caveat that there should be at least an offset of at least 1% so that there's not a deadlock if there's only two co-founders. And finally, you want to make sure that you impose time-based vesting. Again, this is to protect the company in the event that a co-founder decides on day two that they no longer want to be part of the venture. You don't have that particular individual walking away with a huge chunk of the company. Okay, so the next thing we're going to touch on are tips for managing the cap table. So essentially the cap table is essential. It's kind of the record of the pro rata stock ownership of the company between founders, shareholders, and investors. Typically, I've seen that some founders are kind of, incentivized or think it's best to give away large chunks of capital or stock. But we caution against that because, again, this is your company that you're giving away. So every stock or stock issuance or stock option you're handing off, that's a portion of your company that you're giving away. So you want to be somewhat judicious in terms of how you're allocating your stock. Essentially, when you're at the beginning of setting up your cap table, you have a clean slate, you have 2+ founders, and you're kind of figure out, well, how do I allocate my shares? You want to make sure that you allocate shares to the founders first, and then set up your pool, your stock or your option pool for future employees. Typically, what you'll see is if you have a Delaware C Corp, the authorized shares will be about 15 million shares. You allocate about 10 million to the co-founders, and then you have a pool of anywhere from between 10 to 20% is usually what you see for the option pool, and the residual shares would just remain outstanding, not allocated to anyone. In terms of the pool and the option pool and how you allocate those, that just depends on the level of employee that you're going to be bringing on, whether that's a C-level individual, a director, or a regular employee. But the key things with dealing with a cap table, you want to make sure that your capitalization table has the documentation to support it. So in the scenario where you are a couple of co-founders, or maybe one or two two or three co-founders, you want to make sure that you have the right documentation, such as a restricted stock purchase agreement or some type of stock option grant that authorizes the company to issue you or grant you the actual stock that you're receiving. So that it can be tracked back to the cap table, because you want to make sure that the cap table is the center of truth, and it has to have supporting documentation for all numbers and distributions that were made through the cap table. And this will help a lot too as well. I think we'd mentioned it previously in another webinar with regards to if you want to be acquired in the future, just to make sure that your cap table is clean and that investors are comfortable with what inputs there are and what distributions were made. You also want to make sure that you review your cap table pretty regularly with your attorney, with your accountant, to make sure that you're not missing anything, to also keep them up to speed in terms of like any events that may have happened that need to be reflected on the cap table. Now, coming back to founders and the cap table and the distribution of stock to founders. So typically for founders, they will distribute themselves what we call as restricted common stock. And the restricted common stock is essentially common stock that you can acquire, and the right for the company to repurchase that common stock, that reduces over time. So that's what the vesting period relates to. But there's a caution or a caveat. So if you are being granted restricted common stock as a founder, you want to make sure that you also file what is called an 83B election. And what this election does is it helps to lock in your capital gains on any appreciation in the value of the stock you were granted. Most individuals would be pretty well versed, most of your attorneys, I should say, would be pretty well versed in terms of 83B elections. But as founders, co-founders, you should always think that if you're being granted some stock, you should be thinking the next step should be thinking about, well, when am I supposed to be filing this 83B election? Typically, it's 15 days after you sign your purchase document. So it is a very short time window that you want to be aware of. So in terms of a recap, so setting up your cap table, you want to make sure that the option pool is set up after you allocate shares to your founders. And then after the incorporation, the majority of the shares should be allocated to the founders, and only a small portion should go to the option pool, in which you can allocate to employees. So the heftier portion of this discussion is dealing with how do you split stock or compensation among founders. So there's, like the currency for a startup is not going to be cash, right? Your currency at this stage is going to be your equity. So equity is, non-cash compensation that represents a partial ownership in the company. And this is the way that you're going to attract founders, employees, investors. So you want to make sure that the way that you're allocating the stock reflects the inputs or the opportunities that those individuals are going to provide for the advancement of the company. So in terms of how to split equity, there's typically 4 factors you should take into consideration. The first one is salary replacement. So in some cases, some co-founders or employees agree to work for lower salaries in exchange for ownership in the company. Now, this is a practice that some companies do, but you have to beware because there are a lot of issues surrounding compensation and the minimum wage law. And a lot of issues come up with regards to minimum wage law issues and using equity as compensation. So just to talk on some of these cautions. So payment of employees through stock options could violate federal and California wage and hour laws. And as I mentioned before, this is a pretty complex area, and you should probably engage a specialist if you're thinking about using this as an option. The reason why under federal law it is the issuance of stock does not abide by the minimum wage laws is that it specifically states in the Fair Labor Standards Act that minimum wage and overtime payment must be distributed in cash, a negotiable instrument, which is a check, or in some type of room and board or some other type of facility provided to the employee. and that facility cannot include stock. California, it's a little unsettled, but with California, we have the problem in terms of the, not necessarily the minimum wage laws, but with regards to the frequency of pay. So under California law, you have to be paying salary on a regular frequency, and it has to ensure that every month or every couple of weeks you're being paid a salary of some amount that hits the minimum wage law in California. So it's a little difficult if you're trying to use equity as and distributing equity every 2 weeks, every month to an employee in an amount that is sufficient enough to adhere to the minimum wage laws, especially for an early stage company when your shares are of nominal value. So you don't want to be giving away your entire company by trying to pay an employee wages through issuing equity grants. Again, this is a very complicated issue, and you should definitely talk to a specialist in order to get some more information if you're even thinking about using this as an option. There are some exemptions. Some of them deal with individuals who are executives of startups and that own at least 20% of the equity of a company. But again, you should refer to a specialist for that, for further details. Another way to or factor that you want to take into consideration when figuring out how to split up stock and compensation is the idea generation. So who was the individual who came up with the idea for the particular startup? And this is sometimes referred to as sweat equity. And, it may be a single idea that got the company off the ground, and for that reason, you may want to allocate a little more stock to that particular individual. But you have to make sure that the initial thought or idea does not sway against how much another co-founder can contribute in order to move that idea forward. So it is, again, a balancing act. So typically you would allocate a bit more of the equity to the idea generating co-founder, but you don't want to do that at the detriment of understanding what the other co-founders can contribute in order to move that actual idea forward. The second or third thing you want to take into consideration is the stage of the startup. So typically, if you have individuals or founders coming in relatively early before any seed investment has occurred or any Series A investment has occurred, you typically give those individuals more equity because they're coming in at a time when the viability of the company is not yet determined. So that's something that you usually take into consideration, and will allocate maybe a little more stock to those particular individuals. And then another thing to consider is seed capital. So in terms of whether the initial stockholders, whether the original initial co-founders had put some money in to the company in terms of moving forward a particular idea, that is sometimes where you would see a difference in allocation of equity, just to compensate that individual for putting in the initial cash capital to get the idea off the ground. So again, some things to think about for equity split. So the salary replacement, again, be very cautious in terms of using this as using equity as a salary replacement. There are a few exceptions, but again, this is a very tricky area that you should engage a specialist in order to make sure that you're not falling offside of wage laws in any jurisdiction, especially if you're outside of California, because every state has its own rules with regards to wage law and minimum wage law requirements. Idea generation, typically you'll have the allocation of a little more stock to founders who have provided for the idea of the particular startup. But again, you don't want to allocate so much stock that loses sight of the contributions that other co-founders may have to actually get that idea off the ground and into a viable business. Startup stage, again, as I mentioned, if it's in the beginning of a startup, individuals who come on before any type of financing has come through the door typically get a little more in terms of equity, just to as a reward for coming in at a time when who knows if the company is viable or not. And then seed capital is just relating to whether a co-founder or a couple co-founders have actually put in cash to help move the idea off the ground. So equity-based compensation, and early exercise. So in terms of the distribution of equity, there's a couple ways you can do it. Some founders, if you have co-founders, you typically, especially if you're two co-founders starting at the beginning of a corporation, you're going to start beginning and you're going to incorporate together. You usually issue what's called restricted common stock. And as I mentioned before, that means that you are all common stockholders, you have shareholder rights, you're on the cap table. Another option, if you are adding perhaps maybe a founder after the fact, is to issue stock options to that particular founder, but allow them to have an early exercise of those options. So what that means is that even though there is a vesting requirement set on the early exercise options, the particular employee or co-founder can exercise those options before the vesting occurs so that they can benefit from paying for the stock at a time when the options have not increased in value. And so the benefit of this is that you don't have a whole bunch of individuals on your cap table that are shareholders right away. So you can grant options and still have those individuals feel incentivized to work towards the advancement of the company because they do have this early exercise option. This is typically used in early stage companies because it's better because the strike price for your stock options, especially at the beginning, are relatively low. So individuals should have the resources in order to exercise their options and be able to lock in that lower value and lower appreciation in the upsell or the increase in the value of your stock. Again, if you do find a situation where you do have or you are being issued early exercise options and you do exercise those early exercise options, you want to make sure that you also do file an 83B election because, again, that kind of locks in your capital gain for any future growth that the company may have in the value of the options. So just to recap here, early exercise options allow you to exercise your options shortly after they're being granted. And if you file an 83B election, you can lock in the lower value for tax purposes. And that's something that could be very valuable given the fact that some of these shares can appreciate quite quickly over time. I just have a variety of just other considerations that you may just want to think of. That when you're thinking about allocation of options or stock to co-founders, one consideration is that anyone with equity share of less than 10% should likely be categorized not as a co-founder, but as a first-time employee. More co-founders does not necessarily mean equal is better. As I mentioned before, if you have two co-founders, that's fine. You typically want an uneven number so that there's not a lot of deadlock. Or if you do have an even number, make sure that there's some type of 1% differentiation so that you don't end up in a situation where there's a deadlock between voting on certain matters relating to the company. As a general caveat, emotions shouldn't influence equity split arrangements. You should really try to assess the value that each holder is contributing objectively, even though you may have close personal ties. And this is just to make sure that if in the future, that there are any concerns in terms of how equity was allocated, it's easier for you to point to, or all members of the founding team, to point to objective criteria or objective facts that were used in order to determine what and how you allocated the stock. Another thing is just consider having all of the founders talk with an attorney together so that everyone is on equal footing in terms of the information they've received. And it doesn't seem that perhaps maybe one or two co-founders are getting all the information and then relaying it to the other founders. So that's something that you really want to make sure is that you approach your attorney as a group and have this discussion openly. Again, it prevents for any future concerns that maybe there were misgivings when there was an allocation of shares in the past. And finally, I would say you want to make sure you properly document ownership. We've had, or I've seen a lot of situations where there isn't the proper documentation in place in terms of just stating that you've acquired a certain number of shares. It's important that you actually pay for that certain number of shares, even if it's a nominal amount. It may be, as a founder, you may only be paying $2, which is fine. There should be a paper trail of your $2 going from you to the company's bank account. And also another thing is just to make sure that you file your 83B election, because that's a very important thing that will lock in your gain and will prevent you having to pay tax on any appreciation in value in your company.
Awesome. Thank you so much, Natasha. That was a lot of information. We're going to move on to the Q&A section now, so please submit any questions that you have, and we'll try to address them. So the first question we have for you, Natasha, is, do you have any tips for creating a founder vesting schedule that's not tied to time, but instead tied to a company milestone?
So I would say that you could get creative. The only problem is that making sure that you're defining those milestones sufficiently. I think time is an easier and more objective manner in terms of just establishing how, for people being clear in terms of when they've met a certain criteria. I think sometimes when you try to do vesting that is kind of action-based, you could have disputes in terms of whether that action or objective criteria had been met. But if you just have the passage of time, there's no dispute. If I've been here for a year, I get X. If I've been here for this period of time, I get Y. But I have seen scenarios where people have used milestones as a way of vesting. But my recommendation would be to use time.
Okay. So what happens when an employee vests some shares and then leaves the company prior to them raising a Series A?
So if a employee vests shares, it depends on if they've left. So if you vest shares, the shares that you've vested, if they're stock options, you have the opportunity typically it's up to 3 months after you've left to exercise those options. And what that means is that they have to actually pay for the shares in order to become shareholders. So just because you vested in stock does not mean you're necessarily a stock owner of the company. You still have to pay for that equity. All the option does is it says that the company is promising to sell you a certain amount of shares at a set value. So to the extent that that individual does not exercise their options, or i.e. pay for the stock within 3 months after they've departed, then the vested shares are no longer available for them to acquire.
Awesome. Can you speak a little bit to consulting contracts? What does that look like in terms of equity and compensation? Do minimum wage requirements stay the same? And then are there any differences depending on if they're on site or if they work remotely?
So for consultants, you just have to be very careful, because this question is sounding more whether you're trying to determine if a consultant would be considered an employee or a consultant. So you have to be very careful in terms of making sure that a consultant is actually, in fact, a consultant and not couched, not an employee guy under the guise of a consultant, because you can still trip on the minimum wage law issues, regardless of whether you give them a consultant title. If they fall within the requirements of the factors that allow or consider them to be an employee, they'll be considered an employee and therefore entitled to minimum wage law requirements.
Cool. And when a startup raises subsequent rounds, who usually gets diluted? The first founders equally, the option pool. What do you see most often?
So the first equity round, typically all shareholders get diluted. The option pool may be changed in some equity financings. It just depends on what percentage you start off with in the beginning, if it's relatively small or if it's larger. But typically all common stockholders will be diluted equally.
Okay, and I think we touched on this a little bit before, but how much is typically set aside for the employee option pool? What class of shares are these typically?
So you usually would have anywhere from 10 to 20% would be set aside for the stock option pool. And the option pool, as I mentioned, options are just a promise by the company to allow for an employee to purchase common stock in the future. So the shares that are set aside are essentially your common stock.
Awesome. We've gotten a ton of questions, and keep submitting them, please. We'll try to answer one or two more before we close out. And if we're not able to get to them, feel free to send them our way via email, and we'll do our best to get them answered for you. Moving on to the next question, what tends to be the total minimum or maximum of equity to co-founders and very early employees? Meaning, what do investors typically look for?
Yeah, so I did a little bit of looking into this. So it depends on if you are looking at, so if you're just first, no investment, you're pretty much just been incorporated, what the investors would typically look for is that the majority of the stock would be allocated to the founders. And then, as I mentioned before, that there would be a pool from anywhere to 10 to 20%. And the pool can be allocated anywhere from 5 to 10% for CEOs down to say 0.2 to 0.33% if you just have like a junior engineer or someone who's like a staff level member. So typically those numbers are what investors would be looking for, and would not be considered anything jarring that they would, see.
Okay, and the last question that we're able to get to today, what are some equity benchmarks for first employees?
So as I mentioned, equity benchmarks. I'm not quite sure if you're just referring to what percentages of stock options they should be granted, or if you're referring to when employees should be given options. So I'll address both. For employees, again, if it's an early stage company and you are unable to pay them high wages, most startup companies will use the equity as part of like their incentive package to come on as an employee. If you're an early stage employee, depending on what level you're at, if you're coming in as a CEO, your options would probably be higher. As I mentioned, it could be anywhere from 5 to 10% versus if you are, say, an employee who is maybe like a junior engineer, or you're maybe a director or something of that nature, your options would probably be 0.4, 0.5% of the total option pool.
All right, and that closes us out for today. Thank you so much, Natasha, and thank you everyone for attending. As a reminder, we will be sending out a recording of this webinar for you guys to view on demand and share with any of your co-founders that may be interested.